Hello, Michigan Realtors, and welcome back to Letter of the Law. Over the last year, we've been fielding a number of questions on the practice of wholesaling. Now, by wholesaling, we mean where a buyer enters into a contract to purchase property with a seller and then immediately markets that property to other buyers. A wholesaler, unlike a flipper, does not actually take title to the property or only takes title for a very short period of time, typically hours rather than days. Further, this practice has become significantly more sophisticated than the hand-drawn sign at the highway exit offering to buy houses for cash. Now, we continue to receive a number of follow-up questions about this practice. Some members want to know why the practice is not simply illegal. Others point to the number of seminars out there and conclude that it must be a legitimate business model. Based on all of the interest in this topic, we felt that it was an appropriate time to offer a discussion on point. Unfortunately, while we know this practice has landed on the radar of the Michigan Attorney General, the analysis is not as straightforward as we would all like it to be. Consider the following hypothetical. A buyer enters into a contract to purchase a home for $50,000 and close within 60 days. As soon as the purchase contract is signed, the buyer immediately begins looking for someone who will buy this same home for $60,000. On its face, this is a fairly straightforward transaction. Some states, including Michigan, require such a buyer to have a real estate license if they sell their own real estate on a regular basis. For instance, individuals who sell real property for themselves as a principal vocation, that's defined as more than 5 real estate sales in any 12-month period, are required to be licensed. However, much of the debate comes down to whether the practice constitutes a sale of real estate. The Attorney General is reviewing these types of complaints on a case-by-case basis, but the more detail that can be provided in the complaints help investigators make a determination of whether the particular practice fits within the definition of brokerage. Now, for the sake of this video, let's assume that this is not necessarily a violation of license law. What are the risks that licensees should be mindful of when looking at the practice? Understanding your role and the perception. Whether a particular wholesaling transaction is questionable depends on how it is structured. Now, what was the seller told? Now, what happens if the initial buyer cannot find a second buyer? If the first buyer will purchase the home whether or not a second buyer is found, this appears to be a straightforward above-board transaction. This is true unless the first buyer initially had a fiduciary relationship with the seller, or the seller reasonably believed that there was such a relationship. A licensee who has a fiduciary relationship with a seller cannot then purchase that seller's property with the intent of making a profit. But what if the wholesale buyer does not intend to close the transaction unless they can find a second buyer? It is often the case that in a wholesale transaction, the first buyer structures the contract with the seller so that they can walk away from the transaction if they cannot find a second buyer. If the contract states that the first buyer can walk under those circumstances and perhaps forfeit their earnest money deposit, then again, the transaction appears to be wholly above board. On the other hand, what if the first buyer's out is hidden within another contingency? For example, what if, for this purpose, the contract is structured to include an unusually lengthy inspection contingency? There is nothing illegal about a lengthy inspection clause, even one that runs right up until the day of closing. Moreover, it is often the case that an inspection contingency clause is drafted in such a way so that it does not require the buyer to justify their claim that the inspection results were unacceptable. There are certainly other situations where a buyer has terminated a purchase agreement pursuant to an inspection clause based on a decision that had nothing to do with the condition of the property. Now, does this mean that a wholesale buyer can enter into a purchase contract and then use the inspection contingency to terminate the contract if he is unable to find a second buyer at a higher price? On the other hand, what if the wholesale buyer does find a second buyer and the seller objects to the whole profit that the wholesale buyer is making on the resale? In either case, if challenged, will a court simply enforce the contract as written or have sympathy for the seller and examine the underlying transaction? Now, one of the primary reasons that this practice is viewed dubiously is that it is unlikely that any seller would sign a purchase agreement if they understood that the only way the buyer will actually close on the sale is if they can resell the property for a profit before they ever take title. But how far would a court go to protect a seller who signed a legally binding contract that he or she obviously did not understand? While presumably the equities in this situation fall on the side of the seller, it is true that in many of these cases, ruling for the seller could require a court to stretch some well-established contract principles. Such principles include contracts are to be enforced as written, and parties to a contract are presumed to understand what they are signing. But it is also true that a judge who is sympathetic to such a seller would have some legal arguments available to him or her. For example, if the first buyer is a real estate licensee, the court may examine the relationship between the seller and the first buyer. Was it clear to the seller from the start that the real estate licensee was not representing the seller? Or did the seller reasonably rely on the licensee's advice? Is the transaction a disguised net listing transaction that is prohibited by the Occupational Code? Whether or not the seller is a licensee, a sympathetic judge could also conclude that under the circumstances, the first buyer had no right to terminate the purchase contract under the inspection contingency clause. A few states and cities have begun trying to regulate wholesalers. Several states have amended their real estate license laws to specifically state that the sale of a contract for the purchase of real estate also requires a real estate license. The city of Philadelphia, for instance, has adopted a wholesaler licensing requirement and a disclosure requirement aimed at helping sellers find resources that will help them determine the fair market value of their home prior to signing a sales contract with a licensed wholesaler. In all events, a wholesale transaction can easily lead to a protracted legal fight, the optics of which will not be great for either the agent involved or their broker. Now, whatever time-tested legal principles are involved, asking a court to enforce a contract that no one would knowingly sign is a very awkward position to be in. Brokers who have agents in the wholesaling business also need to understand that, as a general matter, claims arising out of the purchase of property by an agent are excluded from the broker's insurance coverage. Thank you for tuning in for this new installment, and while the current analysis undoubtedly raises more questions than concrete answers, this is an important subject to understand from a brokerage and consumer protection perspective. If you have any follow-up questions or would like more information on the state of Michigan complaint process, please don't hesitate to contact us at the email below. Again, thanks for watching, and we'll see you next time.